Well, good afternoon, and it is very clear. What we said, there is no ambiguity about it. The decision of the court that Mr. Quayson should not hold himself out as MP-elect for Assin North, and also he should not present himself before Parliament to be sworn in as a member of Parliament for Assin until the matters in dispute in respect of his qualification to file his nomination papers before the EC and even to contest has gone into and then determined on its merits. So that is the decision of the court.
Well, what evidence did you present to the court? First of all, break this down for me. What were you asking the court to do in the interim?
No, that is exactly what we have asked the court to do. That is to restrain him.
To restrain him.
If you look at the documents we have available to us, you will realize that Mr. Quayson has a Canadian passport. He had a Canadian passport and a Ghanaian passport. And also you realize that Mr. Quayson got his certificate of renunciation on the 26th of November 2020. Now, we also had a travel history of Mr. Quayson. All the documents suggest that at the time when he filed his nomination with the Electoral Commission, Mr. Quayson was still holding on to his Canadian citizenship, had not renounced the citizenship prior to filing his nomination with the Electoral Commission. And EC ought to have disqualified him as such, but they did not disqualify him. And they allowed him to go through the system and then to come over to win the elections. And our law fronts on it. Anybody who wants to be a member of Parliament, the law is very clear that you must not owe allegiance to any other country other than Ghana. Unfortunately, at the time when he filed, at the time when he contested, he was still holding on to his Canadian citizenship. Now, when we presented this certificate of renunciation before the court, interestingly, he didn't deny it. He brought the same document before the court to show that, yes, that is his document. And the date on it is very clear that the date was post-filing. It was post-filing. It wasn't pre-filing. So clearly, the court is in no doubt to injunct you because you can't put something on nothing. The Constitution is quite clear. You can't put who was at the time of filing the very foundation of your application or your qualification is in dispute, is in issue. Definitely, the court cannot put you in Parliament whilst we litigate the matter. The court cannot endorse a wrong in any shape or form. So clearly, that is what the court has done. He is injuncted. He cannot be sworn in as a member of Parliament until the matters in dispute are determined by the court.
So the substantive matter will now be heard. Do we know when that starts?
The case is going to take its normal course. Like normal cases take its normal course. The good thing is that now they have not filed their answer. So they have to file their answer to the petition and then we proceed from there. But this application was heard on notice. Their lawyers were in court. They argued their case out. The court heard them. This was not an ex parte application. Though we filed ex parte, the following morning they were in court saying that they have heard about the fact that we have filed ex parte and that the court allowed them to file their response and appraise the position, which they did. So clearly, the arguments were heard. The court heard both sides and came to the conclusion that we have made a case worth considering for an injunction to be held or to be upheld by the court against Mr. Quayson pending the determination of the matters before the court.